County. And I just want to introduce briefly our two speakers today. First, we have Ryan Mayberry. He's from the law office of Todd Rothbard. Ryan has tried hundreds of unlawful detainer cases throughout the entire Bay Area. You'll often find him flying down the freeway from one court to the other, and he's covered every nature of case that there is, in addition to the regular 3-day notice for non-payment of rent. He'll cover all kinds of cases, including breach of covenant, nuisance, criminal activity. He's even done evictions in mobile home, trailer, and marina settings. Ryan has been a super lawyer for the past 11 years and speaks all over at seminars regarding residential, commercial, and affordable housing tenancies. Our second speaker today is Marc Janowitz, and Marc is a tenants rights advocate in the Bay Area. He has been an advocate for the last 4 decades and has worked extensively on housing and tenant landlord cases, has taken cases all the way up to the California Supreme Court. Marc was elected for 8 years to the Berkeley Rent Stabilization Board. He's lectured widely and has even served as an expert witness in landlord-tenant cases. So with that, I'm going to turn it over to Ryan first. Thank you.
All right. Thank you, everybody, for joining us here this morning. And thank you to the Contra Costa County Bar Association for having me today as a speaker. I'm going to go into a few of the processes as far as doing unlawful detainer actions in the county of Contra Costa. One of the things that I think needs to be taken into account just right out of the gates is that these types of cases are taking longer to get through the process than they've ever taken before. The court switched over, I would say I think it was about a year ago, might have been a little bit longer, to mandatory e-filing for everyone who is not a pro per. Now, rather than being able to send, say, a runner into court or any other sort of e-service and that type of thing, and get those cases, say, back the same day or within, 24 to 48 hours, these are now taking probably closer to 3 to 4 business days to get back. So those delays, combined with, say, the processing of any defaults or any other documents that you might be filing, is something to take into account. One of the things that my clients have especially had a tough time with is understanding that the process itself now is taking a lot longer, where, again, if you were able to get a case filed and served on the first day or within the first 2 days, and the tenant didn't end up filing an answer, you could see a lockout date within 3 to 4 weeks in the past. Now, these cases are probably taking closer to about 2 to 3 months to get through the entire process, as opposed to the ability to just get these things done, say, in a month-long process. And so there has been a lot of frustration expressed about that, and it's important to level set those expectations from the very beginning with clients if you are going to start or have been filing these cases in Contra Costa County. Now, the one benefit, though, that I have noticed is that when cases do get set for trial in Contra Costa, they are, in fact, still in compliance with Code of Civil Procedure Section 1170.5. And these cases are getting at least set for their trials, issue conferences, those types of things, depending on what jurisdiction you happen to be in, within at least the 20-day period after the filing of that initial memo to set. So those are some things to keep in mind. The other aspect of it is that it used to take probably roughly about 10 days to 2 weeks, sometimes 3 if they were overloaded, for the sheriff's department to get out and actually do the lockouts. One of the things that I've noticed in the cases that I've filed in Contra Costa is that that's now taking far longer, and that can take anywhere from, again, a month to almost a month and a half, 2 months in some cases, depending on just how busy the sheriff's department is. Another aspect of this that I've had an issue with as far as filing cases is that there have been a couple of clerks where I've actually run into some issues with their practicing of law for whatever reason. And so I've had to schedule calls or meetings with either the presiding judge or the commissioner who handles the unlawful detainers in those specific jurisdictions to discuss those issues. One of the issues that I had mentioned in the outline was one where I had a clerk in Martinez who had convinced himself and everyone else in the clerk's office that somehow if you served a notice by posting and mailing, that somehow added 5 days to your 3-day notice. rather than look at the clear case law that says that that's not the case because of the fact that you post and mail, the clerk was insistent on it. And until I was able to have a conversation with not only the commissioner, but the presiding judge in Contra Costa County, that was an issue. So don't be surprised if you hear things come up that are not correct, and then may have to initiate some sort of a conversation with higher ups in that respect. One of the things that's unique in a lot of respects about Contra Costa County is that you have three different courts, three different jurisdictions under which that these unlawful detainer cases are filed and heard. You have the Richmond district, the Martinez district, and then you also have the Pittsburgh district. And the issue really with that is that you're dealing with three different commissioners, and the potential, if you're doing any sort of jury trials, to be in front of just about any judge who does any sort of civil trials of any kind. So the key there is understanding that, the issues that you might face in one court or the rulings you might get in one court won't always necessarily be consistent. I think that it's important to understand as well that just starting now, we have three virtually brand new commissioners that are hearing these types of cases. The most senior commissioner is the commissioner now out in Pittsburgh, and she has actually been on the bench since January. Before that, we had three commissioners that had been consistently ruling on these cases for us for the better part of the last 2 to 3 years. So the last of those commissioners, Commissioner Dashman, has now just been promoted to a judge. So they will be appointing a new commissioner for Martinez. I believe they're actually taking applications still at this point. So if you're interested, hey, send one in. But, they are going to be brand new. You're going to probably be doing a lot of what I refer to as unlawful detainer 101 when it comes to those types of cases. It's unfortunate, but sometimes you do have to go through that process and help to educate the new bench officers about certain nuances and aspects that they might not necessarily be familiar with. The other thing about the three different courts is that you have three different jurisdictions that have virtually, almost brand new laws when it comes to these types of things. The Richmond district obviously has the Richmond rent control and just cause ordinance, that not being necessarily brand new, but they do come out with regulations on that, amending certain aspects of it on a fairly consistent basis. This ordinance has specific notice requirements. It carries with it very few exemptions as far as, who is subject to it and who is not. I think one of the most important ones that you'll find is that almost virtually all affordable housing is not exempt from the ordinance, whereas in jurisdictions, say, for instance, like San Francisco, Alameda, those types of places, you'll find that most affordable housing is in fact exempt. So important things to keep in mind. Another one is the fact that single family homes are not exempt. In a lot of ordinances, you'll find that those are exempt as well, but that is not the case in Richmond. Unless the primary, the owner is the primary resident and shares kitchen or bath facilities, you're dealing with an ADU, you're going to be subject to this ordinance. Another aspect of it is notices and proofs of service, both of which must be sent to the rent board, not just the notices. They require proofs of service as well. It's good to note that there are higher relocation amounts that need to be paid in the city of Richmond if you're doing any no fault cause terminations or evictions. And again, to just keep in mind, those new regulations are changing all the time. So before you're going to, start a case, especially for anything based on something other than, say, non-payment of rent, it's important to review those regulations and make sure that, everything that your client's done up to that point is in compliance with those. One of the newer and lesser known aspects of the law in that district is the fact that El Cerrito instituted a rent registry. A lot of people, even attorneys, aren't familiar with it. I get probably at least 1 or 2 calls a week saying, Ryan, did you hear that there's a rent registry in El Cerrito? I said, yeah, it's been going on for actually quite some time. So make sure, obviously, your clients are complying with that. Out in the Martinez district, one of the new laws there is the Concord Relocation Ordinance. This now it greatly increases, again, the amount of relocation that has to be paid to tenants if you are, in fact, doing some form of what is considered now no fault cause terminations, if you're doing any sort of removals, owner move-ins, repairs, those types of things. Another new law that's come up is out in the Pittsburgh district. They now have, and in Antioch, they now have rent control. It's very likely that they'll be moving towards a just cause sooner rather than later. So At this point, it's important to familiarize yourself with that. Make sure, obviously, that your clients aren't, in violation of those in any way, shape, or form, especially when it comes to non-payment cases. If there's any form of, notice of rent increase or anything like that that's not potentially valid, you may end up having to go back and go through the ledger with your client and figure out how those things are going to comply with the actual ordinance itself. Some of the common pitfalls that I deal with regard to these types of things, and I apologize, I'm going to be moving here for a little bit because I am about to run out of battery. So my apologies for that. So the common pitfalls that I deal with constantly on these types of things are clients including late fees in their notices, utilities, things of that nature that are, unfortunately not really considered rent and should not be considered rent in those types of situations, especially with the new commissioners. It's definitely going to be difficult as far as trying to be able to determine at this point what these officers are going to allow to be considered as rent in a notice and not. The safest way to go is to just make sure, obviously, that you're putting just rent in those types of notices. Another common pitfall I see is clients using and getting these types of notices served where they're demanding well over a year's worth of rent. Well, and under CCP 1161-2, we can only go back for 12 months if we're going to use the eviction process in order to do that. So I see that very commonly, and oftentimes what clients will attempt to do is say that the rent, the payments that they've made have been applied to the oldest remaining debt on the books. That can be an argument that goes over well in some jurisdictions. It's an argument that can sometimes not go over well. So it's important to advise clients of that and understand that that may or may not be something that any one of the new commissioners at this point are willing to accept or not. Another thing that I deal with is notices that don't meet all of the statutory requirements when it comes to non-payment notices. I see a lot of times, notices that are brought to my office or that I'm asked to review from attorneys that are assigned by attorneys, but then don't comply with the Fair Debt Collection Practices Act under federal law, which is required. So make sure if you're going to be signing notices on behalf of your client that you are in fact complying with that federal law. Another one of the issues I continue to see are not fully understanding how do you get yourself within the confines of the exemptions under the new AB 1482. I see very consistently landlords just thinking that because they have a single family home that they're exempt and not following the required procedures. Say, for instance, that following, July of 2020, that has to be in any lease agreement that is signed between the parties. And I see consistently that that's not being done. In fact, I see probably far too often that, again, especially pro-per landlords are going onto the internet and finding whatever lease they can get their hands on, not knowing that it may not be beneficial to them, that it may be from decades ago. They don't have the required language that's necessary. The final thing that I see a lot of is, and that I'm going to touch on here is that the relocation required for the no fault cause situations under AB 1482 is not stated appropriately in the notice. I see that they will state that they are entitled to the last month's worth of rent, and that is, but they'll fail to state the actual specific amount that is actually required. So that is what I see on a consistent basis as far as the issues that come up. I'm going to turn everything over now to my colleague, Marc. I think I've hit my time frame. I was trying to go quickly, maybe too quickly.
Thank you, Ryan. I think one of the themes from Ryan's part of the presentation is that there's a lot of different regulations, a lot of different ordinances that you have to deal with. And in my focus on Alameda County, that is certainly true. In Alameda County, we have numerous jurisdictions in which the subject premises might be located. And a lot of those jurisdictions have their own local rent and eviction control ordinances, all of which must be complied with in addition to state law, and in some cases, federal regulations, CFRs as well. I'm going to start with some history, but I'm going to do history in reverse order. I'm going to start with the current situation where we find ourselves now, and then just go back and review how we got here. Right now, as we are all aware and grateful, we're coming out of the pandemic. And mostly in Alameda County, the procedures for unlawful detainer as conducted by the court are returning to something like normal, except it is a new normal. It is not the normal of pre-pandemic. Ryan touched on the amount of time that these cases are taking. And as we return to normal, things will be taking longer. There will be more screw-ups. And I'm not talking about by the attorneys or by the landlords or by the tenants. I'm talking about the courts and the clerks. Ryan touched on some of the issues with the clerks. We've certainly got that in Alameda County. The presiding judge in the housing court department, they don't call it housing court, it is simply Department 511, located in the Hayward Courthouse, where all of the eviction cases for the county are sent. They're sent there for the procedures of getting the cases to trial. They're sent there for motions. They're sent there for settlement conferences. The judge there, Victoria Kolakowski, is trying her best to get through earlier the pandemic, and then navigating post-pandemic. As I said, generally things are returning to a new normal in terms of the procedures that the courts have been using. It's not there yet, and a normal that we get to in the foreseeable number of years is going to be a different normal. That's the end where we are now. Just a brief history of how we got here. Obviously, we had a pandemic. In March of 2020, the governor declared state of emergency, and he issued stay-at-home orders. In response to that, Alameda County enacted a sweeping moratorium. Basically, it prohibited evictions for non-payment of rent of any kind, regardless of whether the failure to pay rent was COVID related. It did allow for exceptions, and the exceptions being mostly for cases in which tenants presented imminent threat to health and safety. And so during the pandemic, during these last 3 years, the entire focus, and I'm sure Ryan will agree with this, that shifted from the overwhelming majority being non-payment of rent cases, pre-pandemic, quote unquote, normal times, to health and safety cases of alleged nuisance, disruptions by tenants. And we saw a rise in restraining order cases and in the unlawful detainer cases alleging this imminent threat to health and safety. In response to the general health and safety order by the governor, the state of emergency, the county enacted the moratorium. And in order to enact the moratorium on a procedural basis for the processing of unlawful detainers in the courts, the Alameda County Superior Court enacted Local Rule 1.8.1, which required a procedure for the court and the litigants to go through to allow a case to be served after it was filed. The court enacted a screening process where the same judge would look at the allegations of the complaint. And if the allegations met the health and safety standards, the judge would allow a summons to be issued. And of course, we know the summons is the device by which the court acquires jurisdiction over the parties and over the subject matter. In those cases, after the judge scrutinized the complaints, and she scrutinized to one degree or another, to one level of thoroughness or another, every single unlawful detainer complaint that came before her. And she would issue summonses in the appropriate cases. The summons, in order to make the case that the summons needed to be, was allowed to be served, the plaintiff's counsel were required to submit declarations and ex parte applications demonstrating that these cases come within the health and safety exceptions. This elaborate procedure was created. And so then the cases were getting through, and then they'd be, when the summonses were issued, they would be served, and the tenants would then come in and defend. All of those procedures are, even though local rule 1.8.1 is still in effect, the judge has said, and she's discussed this with the presiding judge and all of the appropriate judges, even though the rule has not yet been rescinded, it is in the process of being rescinded, but it is not yet rescinded. Even though the rule is still in effect, this judge has told us she is not enforcing it anymore. She is not doing that. She is allowing the cases to be filed and the summons issued by the clerk as per normal, as per pre-pandemic times. So that brings us to where we are. Alameda County, and the next phase that we're going to discuss here are jurisdictions in Alameda County that still have within them limited moratorium that we need to know about, because some of the larger jurisdictions, specifically Oakland, Berkeley, and San Leandro, still have moratoriums in place. Even though the countywide moratorium has expired, it expired, the actual moratorium ended, the law terminated February 28th, and by the specific wording of the law, it expired 60 days after that. So the state of emergency was ended February 28th, and by the end of April, the county moratorium was over. So that meant that non-payment of rent cases can proceed. But if the non-payment of rent is COVID related, and if the subject premises are located in San Leandro, Berkeley, or Oakland, the non-payment of rent cases, if the rent in issue is COVID related, still have some time restrictions that you need to know about. So we're going to go through them one by one. We've included the moratoria of those towns in the materials. And I've included a press release from the court, which summarizes some of what I've just said, that the court issued on June 5th. And it was talking about the tsunami, the big wave that's coming, that the court was experiencing in the month of May, post termination of the moratorium, of the countywide moratorium. Let's just very quickly go over the summaries of these moratoria. San Leandro has one in place. San Leandro's moratorium, and I just want to say, in our office where we process hundreds of unlawful detainers, we defend unlawful detainers, where we would never see, and pretty close to never see, eviction cases coming out of San Leandro. We're now seeing a lot of them for whatever reasons in San Leandro. And so that's where I want to dwell on San Leandro ordinance just a tiny bit. The San Leandro ordinance is in flux. A new city council was seated, 2 new members and a new mayor back at the beginning of this year. At one of their earlier meetings in February, they took their existing moratorium that was enacted during the pandemic, and they extended it for 1 year. So on February 28th of 2023, the City Council of San Leandro extended their moratorium to February 28th of 2024, meaning that there could be no evictions for non-payment of rent when the rent alleged to be owed was the result of COVID-related debt. And that could be household income declining because of employment, or household expenses increasing because of increased expenses in taking care of individuals and having to do child care that would otherwise be given over to others, but where people had to do them themselves. Now, the current San Leandro moratorium that's in place expires February 28th, 2024. But next Tuesday, June 20th, on the city council agenda is the second reading of an amendment to that ordinance. That amendment, which passed first reading on June 5th, and this will pass. This amendment to the San Leandro ordinance terminates the previous ordinance early, July 31st. The tricky little thing is the ordinance, this amendment terminating the moratorium will terminate July 31st, but on June 20th, when it has its second reading, it won't go into effect for 30 days. So we have like an 11-day period where the old ordinance will still be in effect. I can only say not to worry about it, but one of the messages from Ryan was that there's so many little pitfalls and details and regulations. Be aware. That's all I can say. So that ordinance, the San Leandro ordinance, will prohibit evictions for non-payment of rent when the failure to pay rent is due to COVID-related loss or increased household expenses. But again, when the new ordinance comes in, that'll only be up to July 31st, and then it's lifted and we're back to quote unquote normal. Now, there is one provision in the San Leandro ordinance, which is interesting, and I draw your attention to it. Section 1, sub capital letter F, which states the landlord, and this is San Leandro, which states the landlord may seek unpaid rent, and it doesn't say just COVID related, any unpaid rent after the ordinance expires, but only after the landlord provides a 180-day notice. So this is untested. It's not, there's, as far as I'm aware, there's been no litigation trying to figure out, explain what that means. Good luck. But it is a very curious and I would say somewhat difficult portion to figure out. From the landlord's point of view, it requires a 180-day notice. That's a pretty long notice. So have fun with that. But again, the message from Ryan, the message from me is that all of these jurisdictions have their quirks, and you need to know them because the notices are strictly construed, as we know in the law of an unlawful detainer generally. And if there are arguments to be made that you have not complied strictly with the requirements, including these local ordinances, then motions can be made possibly to dismiss the case. Quickly going over Oakland. Oakland has in place what they're calling a moratorium step down, a soft landing from the moratorium that had prohibited the non-payment of rent cases going forward. I'm just going to summarize some of it. It's the Oakland ordinance is in your materials. I'm going to summarize some of it. Section 3, except in the case where the tenant presents an imminent threat to health and safety. It is an absolute defense to the unlawful detainer, regardless of the ground, not just non-payment. It's an absolute defense to the unlawful detainer under all just causes allowed under the Oakland ordinance. If the notice was served or expired, or if the complaint was filed between March 9th, 2020 and July 14th of 2023. Read the ordinance, read the dates, and make sure you comply. And that applies to any theory of recovery, any just cause, not just COVID-related non-payment of rent cases. Rent increase moratorium under the ordinance, under this Oakland ordinance. Again, it's Oakland, section 4. For all units that are covered by Oakland's rent control law, Bear in mind, Oakland has two different ordinances, separate ordinances. One is their just cause for eviction ordinance. One is their rent control ordinances. They are two separate ordinances and they are two separate designations. Oakland Municipal, the rent control ordinance is in the Oakland Municipal Code at 8.22.010 et sec. That's the rent control ordinance. Their just cause ordinance is found in the Oakland Municipal Code at 8.22.300 et sec. The rent increase moratorium for all units that are regulated by the rent control law and the units regulated by the rent control law are different from the units regulated by the just cause ordinance. Ryan touched on this for some of the other jurisdictions that he was talking about. That during this period, from March 9th, 2020, again, the beginning of the moratorium, the beginning of the pandemic, through July 14th of this year, no rent increases above the CPI as defined in the rent control ordinances are allowed unless required for a constitutional fair return. As you may know, in rent control litigation, all rent control by California Supreme Court decision, all rent control ordinances must allow rents to increase at least by the rate of inflation in order to be constitutional, in order not to constitute an unconstitutional taking under the 5th and 14th Amendment of the United States Constitution and under the terms of the California State Constitution. Late fee moratorium in Oakland. No late fees may imposed for rent that became due during that same period, March 9th, 2020 through July 14th, 2023, this year, if the rent was late for a COVID-related loss or COVID-related increase in household expenses. In the just cause ordinance itself, under evictions for non-payment of rent, in a non-payment of rent unlawful detainer, it is a defense that if the rent demanded became due during that same period, March 9th, 2020 through July 14th, 2023, and if it was unpaid because of a COVID-related reason. It is not grounds for a non-payment eviction if the amount of rent demanded, tricky little number here under the Oakland ordinance. You cannot evict if the amount demanded is less than 1 month of the fair market rental value of the unit. Now, that's a little quirky technicality. My advice is, and I think Brian would agree, don't bother suing for less than 1 month. Maybe you wait till the next month, till September 1st, because this particular little quirk that the Oakland ordinance enacted creates in itself a legal conundrum. It is not a ground for eviction if the amount of rent demanded is less than 1 month of the fair market value of the unit. The fair market value can often be greater than the rent control rent. But if a unit is rent controlled and you serve a notice for the fair market value, it's probably demanding more rent than is owed because the rent owed is the contract rent, the rent controlled rent. I don't mean that I'm trying to make you experts in this law. What I do mean to communicate is the complexities and the technicalities of these ordinances. So be careful. And I think Ryan would agree. Lease violations under the new amendments to the Oakland ordinance. It can be grounds for eviction for violation of a provision of the lease after a written notice to cease. That's consistent with state law, CCP 1161 subdivision 3. If the tenant has continued to substantially violate a material term of the tenancy, and under those circumstances in Oakland, the landlord must demonstrate that the term of the lease alleged to have been violated is reasonable. Good luck with applying whatever standard is the legal standard there. And it is lawful, and it has been accepted in writing by the tenant. So it builds on the requirements of state law, 1161 subdivision 3, but it provides enhanced requirements. Now, the substantial violation of a material term, that's not in the state law, but it is in case law. So in any event, you had to prove that anyway, but this codifies it. And then there's an Civil Code 827 change of terms of tenancy issue that City of Oakland has imposed on these things, requiring this new change in this ground for lease violation to have been accepted in writing by the tenant. It's a defense in Oakland to an eviction if the landlord has not registered. The Oakland has a new rent registry, and in order to require enforcement, they've made it a defense to an unlawful detainer if the landlord has not complied with the rent registration requirements. The rent registration ordinance is found at 8.22.500 et sec of the Oakland Municipal Code. There are registration requirements. Turning quickly to Berkeley. Berkeley, of course, had to jump on this bandwagon and do its own thing. It's different in detail, but it's not different in general concept. Berkeley has defined two different periods for the purpose of its ordinance. One is called the covered period and one is called the transition period. The covered period has already expired, so it's not really relevant, but you'll see reference to it in the Berkeley ordinance as you read it. So as I said, the covered period is from the beginning of the pandemic, March 17th, 2020, through April 30th this year, 2023. Obviously that's expired already, so it doesn't apply, but it's in the ordinance and you'll see the language and you'll say, what is that? And then you have to go back to the definition section and look at, okay. The transition period as defined in the Berkeley ordinance is from May 1, 2023 through August 31, 2023 this year. So the landlord, pursuant to this emergency ordinance in Berkeley, as a step down from the termination of the general moratorium, evictions are prohibited, except in the case where the tenant presents imminent threat to health and safety. During this transition period that we talked about, up to August 31, there are no evictions for non-payment of rent, except in the case of imminent threat, except if the landlord is moving in, the owner move-in exception. But in Berkeley, you can evict during this transition period up to, or you can serve a notice up to the end of the transition period, August 31st, if the owner is moving in, but only if the unit into which the landlord is moving is the only residential unit in Berkeley that the owner owns. I have set a timer for myself and we're just about done. Let's see here. So the landlord may sue in Berkeley for non-payment of rent that became due from May 1st onward, only if the tenant did not provide documentation of the COVID-related loss. If the loss is COVID-related, the landlord may not sue for non-payment of rent until after August 31. But if the tenant has not provided documentation of a COVID-related loss, then the landlord may sue for non-payment of rent only for rent that became due after May 1. That's Berkeley. I'm going to end now, and with these wishes, good luck. It's complicated as heck.
Okay, so thank you so much, Mark and Ryan, for all these thoughts. And I wanted to sort of jump in with some questions. I know we did have one question that came in, and I think Ryan may have answered it, but I sort of have a follow-up question. So let me just read the question that we did get relating to the Fair Debt Collection Practices Act and the 3-day notices for non-payment of rent. The question was, is there specific language that needs to be included in a 3-day notice for non-payment of rent if it's signed by an attorney? And my follow-up question is it a workaround to just have the owner sign the 3-day notice for non-payment of rent as opposed to the attorney? So Ryan, do you want to answer that one?
Simply yes and yes. The language itself is about, I would say, 15 to 16 lines long, so I can't type it directly into the chat, unfortunately, but I'm happy to send out what the required language is, say in an email to you, and perhaps then it can get circulated at that point. But the easy workaround is just to have the client sign the notice. You avoid all of the issues that come with that, the requirements that come with that, the required language, the requirement to respond, those types of things, by just simply having the client sign off on the notice, or an agent for the client signing off on the notice. If they've got a manager or something along those lines, that person can just as easily sign off on the notice as the actual client themselves. So my advice is to simply avoid that if at all possible, and just have the client sign off on the notice. These days, with the ability to get things docu-signed internationally, even, it doesn't make a lot of sense to go through that arduous process of being the one as the attorney signing off on the notice if you don't have to.
Okay. Well, and that I assume, Ryan, you would agree with me that that would extend to any notice, including a notice to cure a monetary covenant other than non-payment of rent. It's probably good form to have the client or the client representative sign the 3-day notice, correct?
Correct.
Okay. And other notices for other matters, a lawyer can sign that, and the language from the Fair Debt Collection Practices Act is not required. Is that correct?
Correct. That is not required for anything that isn't trying to collect some form of a monetary amount of some kind. So, for instance, if you're, the tenant has caused, say, damage to the property or something along those lines, and you're trying to collect the cost of replacement for that damage, I would say that you're falling into the same category. But if you're signing off on a notice for nuisance or some other type of activity that's a different violation of the lease, say pets alteration, something along those lines, then
Unauthorized occupants.
Same idea. Yep, same idea.
Right. And also for notices that are no fault, just cause, like owner move-in and so forth, that's fine for attorneys.
Fine, absolutely.
Okay. Okay, we had a question actually in the chat about post-judgment claim of right to possession. Question is, does the post-judgment claim of right to possession procedure contained in the unlawful detainer statutes apply in the enforcement of an ejectment judgment? That's a very good question, actually. I don't know the answer to that.
I mean, I think it's an interesting question from an ejectment standpoint, being that ejectment is done under a completely separate cause of action and a separate set of laws.
Mm-hmm.
So I think you'd have a tough time arguing that somehow an unlawful detainer statute applies in an ejectment action. But I actually have never encountered that. I deal with post-judgment claims of right to possession regularly, but not from an ejectment standpoint, just from an unlawful detainer standpoint.
Right. And
Yeah,
but I think with an ejectment, you do get a writ of possession at the end of the day with your judgment, correct?
I believe so, yes. But I also think that in an ejectment action, I don't know if they call it necessarily a prejudgment claim of right to possession. It's called something different, but I believe you can close the loop on that at the beginning of your ejectment action as opposed to dealing with it afterwards. And frankly, if you're going to go through the process of ejectment, which if unlawful detainers are taking a long time, I can tell you ejectments are taking especially a long time. I would say close that loop ahead of time rather than relying on some sort of post-judgment when you could have gone through 12 to 18 months worth of litigation to get your judgment in the ejectment action, and then have somebody say, well, I'm here too.
Yeah, well, bear in mind, as both both Ryan and Maria are pointing out, ejectment is not a summary procedure like unlawful detainer. And so with the question interjecting the concept of ejectment, then we as lawyers have to say, oh, that's a normal civil action. And so, okay, fine. Just settle in and have your martini. And 2 years later, you might get a trial date. So it's questionable as to whether the post-judgment or pre-judgment claim forms even apply, because those are within the unlawful detainer context. So,
Right.
but as Ryan said, do your homework and figure out who's living there and all of that.
Right. And oftentimes with these ejectment lawsuits, there's other matters being litigated, other causes of action, and that's sort of thrown in as an add-on, but not necessarily the main focus of the lawsuit. I guess the second question we have here, in eviction lawsuits and in ejectment lawsuits, can the issue of whether or not a lease is valid or invalid, including a fraudulent lease or a lease that's not bona fide, be litigated? It's an interesting question.
Not in a separate cause of action in the
you can't bring an
detainer.
affirmative claim, right? You can't bring an affirmative claim for fraud in the inducement or whatever.
Yeah, and bear in mind, if you have any kind of non-unlawful detainer related cause of action, that will defeat the summary nature of the unlawful detainer part of it. If you wanted to all the benefits of the short time periods for unlawful detainer, if you added some cause of action like that, that would defeat that. That would be a motion to quash or some motion to strike.
But I think that a tenant could raise as an affirmative defense to an unlawful detainer the fact that the lease is fraudulent. I suppose that could be an affirmative defense.
Absolutely, and that may or may not actually result in a defense to possession. I mean, you're still in possession. The tenant is still in possession. Then the question would become by what means, by what agreement?
Grounds?
Yeah,
right. And are you an at-will tenant? Are you at sufferance? Whatever. Then you're sort of going into other types of tenancies.
Yeah, and maybe that would result in some motion, some argument that the tenant would be able to make for dismissal. If it's an at will, then you need a notice pursuant to 789 of the Civil Code, 30 days. So maybe or maybe not, it would result in ultimately in a successful defense.
Okay. So I don't think we have any more questions. I do have a few more questions I wanted to ask. Actually, for Ryan, Ryan, you talked about situations where the tenant pulled a lease off the internet. It doesn't have the required TPA exemption for single family residents owned either by an individual or an LLC, blah, 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 the language of the exemption. And I've had that happen too. But Ryan, are there ways to sort of overcome that? Can you add that language in after the fact? Can you modify the terms of the lease? And if so, what are the steps for doing that?
And this is going to touch on one of the things that Marc touched on, which I think is especially important, that in certain jurisdictions, Civil Code 827 isn't available to you from the standpoint of unilaterally changing the terms of your lease agreement. Berkeley, Oakland are have made it clear that that is not an option. One of the things that I did not touch on, but I'm glad you brought up here is that Richmond has the exact same language. So if you didn't do it in Richmond, then it's not something you could say serve as a 30-day notice of change of terms. Just about every other jurisdiction, provided the agreement has gone to a month-to-month, you could in fact serve a Civil Code 827 notice and then just simply change the terms of the lease to have that provision stated therein unilaterally on your own as a landlord. But if you haven't done that in, say, a jurisdiction like Richmond, or what I suspect will soon be a just cause jurisdiction, say out in Antioch here in the near future, because they're looking at the exact same type of language, type of just cause ordinance to partner with their rent control, then you could have a serious problem on your hands if your client did not in fact do the lease appropriately from the very beginning.
Yeah, I believe there was a city council meeting just this past week here in Antioch. Okay. Ryan, one more question for you, and then I have a couple for Marc. Ryan, you talked about some of the difficulties of the, sending court filings in, e-filing and so on and so forth. Is there another workaround there too? I've heard, and I know some landlord attorneys, if they can, if, for example, the landlord is an individual, send that individual in to file and then do a substitution of attorney. Have you done that?
I do not. I like to be on the pleadings from the very beginning. I like to be the point of contact. So that's just more of a means of practice decision. I think it can get complicated depending on when you get that substitution in, especially if you have a defendant that is interested in fighting the action. If your client is, say, served with discovery or something along those lines, which can be served at any point by the defendant, even before they answer in unlawful detainer cases, and your client doesn't answer that timely, you could find yourself either having to dismiss that action, start all over again, find yourself waiving objections to a lot of information that may not be relevant to your case. So I don't see that as a real workaround that's going to be beneficial in the majority of situations. I think maybe on a case-by-case basis, if you're talking about somebody going down there and filing it, bringing it back to you, signing the substitution, and then filing that, e-filing that the same day or something along those lines, potentially. But, it would really depend on the volume of your practice. I could just say with the number of cases that my office files, it's just not practical to do that. But if you're, say, doing a one-off or, a couple of cases a month, perhaps that could work. But you're putting also a lot of trust in your client to go down there and deal with, unfortunately, what's been my experience is in the clerk's office, a lot of people that are trying to put roadblocks in your way to getting things filed, not simply just accepting your documents, stamping them, and going through that process. So, I would say you're putting, like I said, a lot of trust in your client in that respect. And if that's the case, wonderful. I would advise against it, though. I just don't think it's something that's going to, in the long run, say you do 10 of those types of cases and one of them goes awry, the issues you're going to deal with in that one case are probably going to take up as much time as if you just did all 10 cases the right way from the very beginning.
Right. Okay. So Marc, I had a couple questions for you. I was very fascinated by your explanation of all these different local ordinances. So for San Leandro, does San Leandro allow Ellis Act evictions? And if so, do they have an Ellis Act ordinance?
Funny you should ask, right, Ryan? Because I think Ryan just filed one of those in San Leandro. They do not have their own Ellis Act ordinance. And for the audience, I would just say Ellis Act, as most of us know, is a ground for eviction authorized by state law, Government Code Section 7060, and it exists on state law. Some jurisdictions, as allowed by the Ellis Act itself, have enacted enabling statutes, enabling ordinances that go along with the Ellis Act. And some jurisdictions, San Francisco, Oakland, Berkeley, have elaborate additional requirements if you're proceeding under the Ellis Act. And when the jurisdiction does not have those, then you're just left with the Ellis Act. That is San Leandro. San Leandro does have a relocation ordinance which applies in the Ellis Act situation, but it doesn't have a lot of the requirements that other ordinances, other jurisdictions do. So and they can be tremendously additionally required, a huge amount of other requirements to do Ellis Act into these other jurisdictions.
So, and then just to recap for the audience, if you don't have an enabling statute for those jurisdictions where it's just the state law, what are the notice requirements for an Ellis Act?
Well, it's a 60-day notice, right, Ryan?
Correct.
And I say that because other jurisdictions have 120
or 1 year.
And then extended to 1 year if the individual is disabled or senior and has been in the home for 5 years in different periods. But it's a 60-day notice in these jurisdictions that do not have their own enabling ordinances that are added on top of the Ellis Act as the government code sections.
And just to chime in, just from a landlord's perspective too, especially on the issue of San Leandro, the San Leandro City Council, along with the mayor, have had many discussions already about enacting their own just cause ordinance. I think, Marc, you actually spoke to the city council at one of those, or maybe even two of those meetings that they've had. So that San Leandro is a perfect example of a rapidly changing landscape from a legal perspective. under which that we could see a just cause ordinance enacted there probably before the end of this year. I don't think is entirely out of the question, but that's the reason why you have to really be paying attention to these things if you're going to practice in these jurisdictions, because again, it's an ever-changing landscape, whether they've got an ordinance and it's changing from a regulation standpoint, which, again, Mark, you can probably piggyback on this. Oakland just changed its rules on several different levels from a regulation standpoint back in November of last year. They took basically, you used to be exempt if you had a certificate of occupancy after 1995, and they went to a 10-year rolling exemption. I have a whole group of clients that are now no longer exempt, and they think that they're exempt because they have been for the better part of almost 3 decades now. So
was a
yeah,
ballot
and I
initiative.
believe there's also exemptions if you have school-age children,
Right.
if you have.
For owner move in and for Alice, those were ballot initiatives on the November last year, 2022 ballot, that the rolling exemption that Ryan referred to. Yes. And the school age children prohibition against evictions during the school year.
Okay.
All kinds of things like that. And the issue of San Leandro is one of the reasons why I spent a little bit of time saying how the existing ordinance is in effect until this date, and then the new one comes in, but it doesn't start for 30 days. Yeah, can be tricky. It can be tricky.
I have one last question, and then I think we'll be done. And this is what would you do? And I'll ask both of you or whoever wants to jump in first, but using the rent control ordinance, that little quirk that you were talking about, Mark, as the springboard, the example that I wanted to throw out there is, let's say you had a tenant, their share of the rent is $600, the subsidy is $1,800, so it's a $2,400 monthly payment that the landlord's getting from the combined sources. What would you do if the tenant doesn't pay the $600 their share in, say, August of 2023 in Oakland? What would you do, Mark? Or no, should I ask Ryan first?
Me? I would vigorously defend.
I know,
that's what I would do.
Pretend that you're Ryan and you had to serve a notice. What would you do?
If I was Ryan, I had to serve a notice. Well, I would make sure that it was my office's name that was on the notice because of the fair debt collection. No, we'd have the landlord serve the notice. And you said
It's 600.
Well,
so would you wait 4 months?
Well, the first question is it COVID related? Because that's an issue. Is there evidence of COVID related? That's something I didn't mention, which is a little aggression, but it's a significant one. The Oakland ordinance says that tenants shall report to the landlords whether or not they have COVID related rent inability to pay. They shall do that on a form generated by the rent board. Guess what? The rent board hasn't generated that form yet. Okay, what do we do about that? Well, I think that any reasonable judge or any reasonable landlord would understand, well, I'm going to generate my own form. And I think all of this is a way for me to avoid directly answering your question.
Let's pretend that they gave you the form. It's all that it's not COVID or it's not COVID related. I'm just talking about that little quirk about that it can't be for less than 1 month. Right. So, but would you wait? Would you wait 4 months? Still, you hit.
Well,
well, I think then you enter the fair market value argument, right?
Yeah. Well, that's
the fair market value of the rent. It's not always going to be the case, and in fact, the discussion that went into that change was the idea that, okay, what do you do if you do have a subsidized tenancy? Okay, well, we're going to add this language that talks about the fair market rental value. Well, clearly the fair market rental value is delineated in the HAP contract as being the combined portions of both the tenant and the housing authority. Now, your issue is going to be, I think, more along the lines of, do you want to invest the money in an unlawful detainer action over $600? I think that might be the more operative question, but I would probably advise the client out of the gates to say, look, you're entering muddy waters, to put it lightly, something that has no appellate decision on it, something that hasn't even been decided at this point by even the judge who handles these types of cases, let alone if you ended up, say, in front of a jury or something like that, what they're going to say or feel about it. I would probably advise someone against going forward on something on an amount that's that small, just because of the fact that if you were to end up in front of, 12 community members in a jury box and trying to explain why you're going after somebody for $600 who has a subsidized tenancy, I don't think puts you on the right foot going forward anyway. But if your client's insistent on it for whatever reason, then I don't think it's that you could not proceed. I think it's important just to advise of all of the pitfalls that are potentially going to be there, because again, you don't have clear case law on this, right?
No.
We've got 150 years of unlawful detainer case law, none of which has dealt with any of these issues that we're currently talking about right now, as far as COVID-related rent. Even the provisions of AB 1482, there's very little appellate decisional law on that as it stands right now as well. So you're really just entering an arena that is just not well established at this point. So you need to be prepared for just about every scenario, and it could go against you, and it could.
And I just wanted.
On
And
a
I just wanted
case-by-case basis, by the way.
to take what Ryan said and to emphasize how important one of the concepts Ryan just said is, you need to take the holistic approach. You need to look at the entire thing, all of the factors, including the potential of getting in front of 12 community members on a $600 debt for an individual who is already suffering some of the detriments of our society because they receive a rent subsidy. This holistic viewpoint is very practical, very real, and very, very important.
Right. And I guess the same can be said for including late fees and all that in notices.
Be careful. Be careful.
Be careful, and it's probably not worth the risk, once again, of being in front of a jury and fighting over a late fee that may or may not be deemed part of the rent.
Yeah, and what we see is, we know a lot of times you have to talk your clients out of it. They have issues, they've been dealing with the tenants, they're frustrated, they're angry. We understand all that, especially now coming out of COVID. But there are the practical considerations that Ryan refers to that are just as important as the legal technicalities.
Yeah. Okay, I think that's it for the questions. I don't see any more. I'm going to hand it back to Sarah.
Thank you. Thank you both for that presentation. Very good. I want to just remind you, you'll get your certificates and your materials in your email, and I hope everyone has a great weekend. Thank you, Marie, Ryan, and Marc, for doing this.
Thank you all. Thank you,
Thank
Marie, for
you.
organizing. Ryan, great to see you.
Likewise, Mark. Take care.
Thank you.
Bye, everybody.
Okay.
Bye.